dealing with the matter of United Trade Action Group and Transport for London and another.
Yes, Mr Matthias.
May it please your lordships, I appear for the United Trade Action Group with my learned friend Mr Charles Streeton. I'll refer to United Trade Action Group as UTAG.
Yes.
The first respondent is represented by my learned friend Miss Maya Lester of Queen's Counsel and Mr Tim Johnston. I'll refer to them as TFL.
Yes.
And the second respondent, Transopco UK Limited, represented by my learned friend Mr Phillips Colvin of Queen's Counsel and Mr Ronnie Dennis.
Yes, you can refer to them as free now if you like.
Free now, yes. Yes, or Transopco. The app is called the Free Now app. The company is Transopco, yes. And this is UTAG's appeal against two aspects of the decision of the Divisional Court comprising Lord Justice Males and Mr Justice Fraser, dated the 6th of October 2021. The judgment in question is to be found at tab 8 of the core bundle, and the order that was made is at tab 7. The first issue, and much the more important from our client's point of view, is the matter for which the Divisional Court granted us permission to appeal to this court, namely the question of whether the driver of a private hire vehicle, a PHV, soliciting passengers by means of the Free Now ride-hailing app, which I call the Free Now app, is plying for hire contrary to Section 7 of the Metropolitan Public Carriage Act 1869, the 1869 Act. And that's the plying for hire issue as defined in the first sentence of paragraph 7 of the judgment below. The second issue concerns a question of whether, regardless of its decision on the plying for hire issue, the Divisional Court erred in making no order as to costs below and ought instead to have awarded UTAG its costs of the judicial review claim, or at least a proportion of them, and I'll refer to that as the costs issue.
Yes. Well, we'll deal with that on a rolled-up basis. You'll presumably make submissions on the main issue, and then you'll make submissions seeking permission to appeal on the costs issue.
If I may, my lord. Yes. Thank you. Now, dealing then with the applying for hire issue. On the 9th of August 2020, TfL decided to grant a PHV operator's license to Transopco under Section 3, subsection 3 of the Public Hire Vehicles London Act 1998, the 1998 Act. It's in the authorities bundle at tab 10. And the relevant section is at page 130. That's the internal pagination of the authorities bundle. We can go to it, but I don't know that there's any particular need to at this stage. Now, UTAG, my lords, is a trade body formed to protect the legitimate interests of hackney carriage drivers, also known as black cab or taxi drivers, and other industry stakeholders, such as those who manufacture and supply taxi meters and card payment terminals for black cabs. UTAG was concerned about the decision of TfL for two reasons, and UTAG accordingly issued the claim for judicial review herein on the 6th of November 2020. The claim is to be found in the core bundle at tab 18. It instigated the claim against TfL as defendant and cited obviously Transopco as an interested party. The concerns were twofold. Firstly, that Transopco was a company that facilitated and encouraged PHV drivers to ply for hire unlawfully in London by soliciting passengers by means of Transopco's ride-hailing app, the so-called Free Now app, and that is the plying for hire issue. Secondly, that on Transopco's own contractual terms, the drivers of public hire vehicles working off the Free Now app were accepting private hire bookings for their vehicles unlawfully, that is to say, without the necessary operator's licenses, and that was referred to below as the operator issue. Accordingly, UTAG contended that Transopco was not a fit and proper person to be granted a PHV operator's license, pursuant to Section 3, subsection 3A of the 1998 Act. In deciding otherwise, we said, TfL failed to have regard to material considerations, namely the aforementioned illegalities that were intrinsic to Transopco's method of operation, and acted irrationally. The Divisional Court, the court below, dealt with the latter concern first, that's to say the operator issue, primarily because additional parties were concerned with that question, namely Uber London Limited, Uber, and the App Drivers and Couriers Union, the ADCU, who were parties to the Part 8 claim brought by Uber in respect of that same question following the decision of the Supreme Court in Uber BV and Aslam. And that was a decision dated the 19th of February 2021. And my Lord Justice Bean, you'll be familiar with that case, I apprehend.
Yes.
Yes. The Part 8 claim was commenced by Uber on the 20th of May 2021, seeking a declaration to determine that question. Now, it'll be recalled that the judicial review claim herein, raising the self-same question, had been commenced some 7 months previously, on the 6th of November 2020. And on the 20th of April 2021, a full month before, Mrs Justice Lang had granted permission and directed that the judicial review case be listed before a divisional court with a time estimate of 2 days. Accordingly, by an order dated the 8th of July 2021, Master MacLeod ordered that the Part 8 claim shall be listed together, but for the avoidance of doubt not formally joined with the judicial review claim currently listed before a divisional court of the Queen's Bench Division. Now, we won on the operator issue, as my lords will be aware from the judgment below, particularly paragraphs 27 to 38 of that judgment. However, we lost on the applying for hire issue. And that's essentially the reason why we lost is in the judgment below, paragraphs 53 to 55. We now appeal to this court by permission of the Divisional Court. And if one looks to the order of the Divisional Court dated the 6th of December 2021, which is in the core bundle at tab 7 on page 94, it will be seen that in granting the order for permission, the Divisional Court said the applying for hire issue is an issue of considerable importance, which is suitable for consideration by the Court of Appeal. The Divisional Court had considered itself bound to follow the previous division of the Divisional Court in the case of Reading Borough Council and Ali, decision 1919, One Weekly Law Reports, page 2635. It's in the authorities bundle at tab 30, which the Divisional Court below regarded as, quote, in all respects indistinguishable from the present case. And they said it is therefore our duty to follow Reading and Ali. The significance of the Reading and Ali case was that it was the only previous case that had addressed the question of whether a PHV driver was applying for hire when soliciting customers by means of a ride-hailing app. However, the Divisional Court did not say in terms that it agreed with the decision in Reading and Ali, or would have come to a similar decision itself, absent the decision in Reading and Ali, and as we know, granted UTAG permission to appeal to this court on that question. The applying for hire issue is, as the court below recognised, an issue of considerable importance, both to the public in general and to the hackney carriage trade, the black cab trade in particular. Of considerable importance to the public in general because the very purpose of the legislation that forbids vehicles other than licensed hackney carriages from applying for hire, that's to say the 1869 Act, and in particular section 7 thereof, is ultimately the protection of the public. It's of particular importance to the hackney carriage trade, and as I say, by which one's referring not only to the owners and licensed drivers of black cabs, but also to the other industry stakeholders to whom I've referred, because the introduction, initially by Uber, of ride-hailing apps on smartphones, enabling people effectively to hail private hire vehicles when formerly they could only lawfully hail hackney carriages, has coincided precisely with a dramatic decline in the numbers of licensed hackney carriages and an equally dramatic increase in the number of licensed private hire vehicles and private hire vehicle drivers. Paragraph 29 of the witness statement of Karen Proctor, which is, it's in the, can I take my lord to it briefly? It's in the supplementary bundle at tab 2, and it's the internal pagination 118. We see that since 2014, the numbers of licensed hackney carriages have fallen by 35%. That's to say 22,810 down to 14,968. Whilst the numbers of licensed private hire vehicles have increased by 61%, 52,811 up to 85,123, whilst the number of private hire vehicle drivers has increased from about 65,000 in 2013 to 104,000 in 2021. And this trend is continuing inexorably. And of course, it's not a mere coincidence, but an obvious case of cause and effect. The advent and increased use of ride-hailing apps, such as the FreeNow app, by private hire vehicle drivers is threatening the very existence and future of the black cab trade. The availability and use of ride-hailing apps has been said to blur the distinction between black cabs and private hire vehicles, or as my learned friend Mr Colvin put it before the Divisional Court, narrowing the gap. London's black cabs are highly prized by Londoners, and we know are recognised worldwide. If I could take my lords to, in the supplementary bundle, to tab 12. This is an extract from Mr Sadiq Khan's 2016 mayoral manifesto, where he referred to an iconic taxi service. As the world's greatest city, it is absolutely right that we have and continue to have the best and most qualified cabbies in the world. London's black taxi drivers are highly trained and properly checked to a high standard, high safety standard, driving wheelchair accessible vehicles with the incredible geographical recall and sense of direction that only those with the knowledge have. With people like this at the wheel, it's understandable that the London black cab is an icon known around the world and a source of pride for Londoners. I will, said Mr Khan, ensure that the markets for licensed cab drivers and for private hire drivers are fair, with special privileges built in, as it always have been, for those who become a licensed London taxi driver. But without being dramatic, and it is not being dramatic, the very existence of that trade is under threat. It will be noted that, as explained by Ms Proctor in her witness statement, to which we've just referred, it's paragraphs 17 to 22 of that witness statement, the internal pages 115 to 116 of the supplementary bundle, that the FreeNow app's predecessor app, something called Halo, was developed and launched in London in 2011 solely to enable customers to hail black cabs electronically. Only since July 2020, when Halo merged with a German e-hailing company called My Taxi and a company called Captain, was the FreeNow app launched to enable both taxis and private hire vehicles to be hailed electronically. And what we say is that its use by black cabs was lawful because black cabs are entitled to apply for hire, but its use by private hire vehicles is unlawful. And whether or not private hire vehicles are indeed applying for hire when working off the FreeNow app, that is the question to be determined on this appeal.
Yes.
Applying for hire is not only the exclusive preserve of the licensed hackney carriage and of stage carriages, that's to say, in modern parlance, buses, it's also a fundamental part of the definition of the term hackney carriage. If I could take my lords in the authorities bundle, please, to tab 7, and that is the 1869 Act.
Yeah.
And if we go to to section 4 of that Act on the internal pagination, internal pagination 56. We see that the definition of stage carriage and hackney carriage. Let's say a stage carriage we now know as a bus, or in the modern statutory language, a public service vehicle. But in the second paragraph of that section, as it were, hackney carriage, the taxi, shall mean any carriage for the conveyance of passengers which applies for hire within the limits of this Act. So that's the hackney carriage is defined by reference to that term. It's furthermore, it is the feature of hackney carriages for which a hackney carriage licence is required. And if we look at section 6 toward the bottom of that page, grant of hackney carriage licences, Transport for London, now Transport for London, Transport for London shall have the function of licensing to ply for hire within the limits of this Act hackney carriages to be distinguished in such manner as may be prescribed. And it is a criminal offence for an unlicensed hackney carriage to ply for hire. And if we see section 7, penalty on use of unlicensed carriages, if any unlicensed hackney carriage plies for hire, the owner of such carriage shall be liable to a penalty not exceeding £5 for every day during which such unlicensed carriage plies. The amount of the fine has now been increased. And if any unlicensed hackney carriage is found on any stand within the limits of this Act, the owner of such carriage shall be liable to a penalty not exceeding £5 for each time it's so found. The driver shall also in each case be liable to like penalty unless he proves he was ignorant of the fact of the hackney carriage being an unlicensed carriage. And then we see, finally, whilst we're on this Act, at section 8, hackney carriage to be driven by licensed drivers, and at subsection 2, no hackney carriage shall ply for hire within the limits of this Act unless in charge of a driver having a licence under this section from Transport for London. It can be seen, therefore, that the concept of plying for hire is not simply an incidental privilege that is accorded to hackney carriages. Rather, it's central to their definition, and it is what they are specifically licensed to do. Given the crucial importance of plying for hire to the entire scheme of the 1869 Act, it's notable that the term is not included in the interpretation of the section of the Act, that's to say section 4, where we find stage carriage defined, hackney carriage defined, London cab order defined, prescribed is defined. That's the definition section. Now, it can't be supposed that in enacting the 1869 Act, Parliament was intending to pose a linguistic conundrum to entertain generations of lawyers and judges through the use of the term plying for hire in the 1869 Act. My lords, as the court below concluded, paragraph 40 of the judgment, we must suppose the term was one that was regarded as requiring of no definition at the time, like the terms conveyance or passengers, that also feature in the definition of the term hackney carriage. Of course, everybody knows what plying for hire means. Parliament must have supposed. It's what horse-drawn carriages do on the streets of London all day and every day. They drive around or stand about in search of passengers who have not previously arranged a hiring. And that's implicit in the term plying, defined in the Cambridge English Dictionary when used in the context of ply for business, trade, etc., as to try to get customers for your business in a public place, for example, as a taxi driver, by driving around or waiting in a regular place. And we've included that definition in our skeleton argument in paragraph 1, you will have seen. Yeah. Now, I'd like to go on, my lords, to deal with the question of what is plying for hire in two stages. Firstly, to address what is, in my submission, the clear purpose of the 1869 Act in restricting the class of vehicles permitted to ply for hire. and then to go on to the central question of then what is applying for hire. Because in my submission, to understand the purpose of the legislation is important in order to understand just what the concept properly understood means. Firstly, if I can refer my lords to the case of Cogley and Sherwood, which is in the authorities bundle at tab 21.
Give me the page reference, please.
Yes, indeed. Yes, it's page 247. It's page 328 of the report. It's 247 of the internal pagination of the authorities bundle. And if I could invite my lord on this question of the purpose, if I could invite my lord for the judgment of Mr Justice Donovan, as he then was, the final full paragraph on that page, beginning when that section was enacted. And he's talking about section 7. Or yeah. We'll obviously need to look at this case in some detail, but I'm just now at the moment focusing upon those parts of it that deal with the purpose of this particular legislation. And
yes.
And central to it, of course, is this sentence: the purpose of the Act of 1869 was clearly to exercise control over these vehicles so as to ensure a proper standard of safety and cleanliness and of competency in their drivers, for the driver had to be licensed too under Section 9. And then he goes on in the remainder of the paragraph that I identified to talk about how the world's changed. In 1959, of course, there were motor cars. They weren't horse-drawn carriages. But said these new conditions do not mean that plain words in the statute are now to be given something other than a plain meaning. Of course, the world goes on changing. And the world in 2022 is vastly different from the world in 1959 and in 1869. Just as motor cars were unimaginable in 1869, so ride-hailing apps were unimaginable in 1869 and in 1959. In the words of Mr Justice Donovan, as he then was, these new conditions do not mean the plain words in the statute are now to be given something other than a plain meaning. They do, however, require the courts to apply the language of 1869 not to the vastly different circumstances of 1959, as the court had to do in Cogley, but rather to the vastly different circumstances of 2022. And as Mr Justice Salmon, as he then was, went on to say in the same case, this is the internal pagination of this authorities bundle at page 250. In the second paragraph, in cases such as these, the member of the public knows nothing and has no time to make any inquiry about the vehicle or the standing or indeed the identity of the owner. It's not surprising that in such cases Parliament should make arrangements that the vehicles which so ply for hire shall be of a certain standard of safety and comfort upon which the member of the public can rely. In short, my lords, the plain parliamentary purpose in passing the 1869 Act was to secure the safety of the public by ensuring that only the only vehicles permitted to ply for hire in London, that's to say permitted to drive around or stand about in search of passengers who had not previously arranged a hiring, were vehicles that had been duly licensed to ply for hire under that Act. That's to say vehicles we now know as taxis or black cabs, and which were thereby subject to the strict regulatory requirements imposed currently by TfL pursuant to Section 9 of the Act. That's Section 9 of the 1869 Act, which is at Authorities Bundle, tab 7, page 61.
Just when you started this process, then you bottled it, and now you come back.
Beg your pardon, my lord.
The strict regulatory requirements imposed upon hackney carriage drivers and their vehicles at the present time include those that we've summarised in our skeleton argument at paragraphs 13 to 16. Our skeleton is to be found in the core bundle at tab 3, and the paragraphs to which I'm making reference are between pages 32 and 34 of the bundle.
Yes.
And as contained in relevant legislation and in TfL's so-called conditions of fitness, which are in those conditions of fitness are set out in the supplementary bundle at tab 18. Furthermore, those strict regulatory requirements are explained in the witness statement of Karen Proctor. That's the witness, we looked at her witness statement already, it's supplementary bundle tab 2, between paragraphs 6 to 16. I don't know whether my lords have had the opportunity of reading any of those referred to passages.
The witness statements, yes.
Yes.
For myself.
And I apprehend my lord has probably also had the opportunity to read our skeleton argument.
Yes.
Yes. The only other document that is important to fully understand the extent and the rigour of these regulatory requirements are the conditions of fitness. I've given the reference to that. I apprehend it's not necessary to go to that now, in addition to the references in the witness statement and the skeleton argument. Yeah. It's there to be seen. It's important to remember that prior to 1998, minicabs were entirely unregulated in London. It's only in 1998 that they became regulated by the Private Hire Vehicles London Act of 1998. And pursuant to the jargon of that act, they became known as private hire vehicles. Now, whilst since 1998, private hire vehicle drivers and their vehicles and their operators licensed in London under that act are subject to certain regulatory requirements. The relevant requirements are very significantly less onerous and restrictive than those imposed upon hackney carriage drivers and their vehicles. And it is unlawful for private hire vehicles to ply for hire, as we know. Adopting the wording of Mr Justice Salmon as he then was in Cogley and Sherwood, which we've already referred to, since the member of the public knows nothing and has no time to make any inquiry about the vehicle or standing of the driver plying for hire, it's not surprising that Parliament should require that the vehicles which so ply for hire shall be of a certain standard of safety and comfort upon which a member of the public can rely. And put shortly, private hire vehicles and their drivers are not of that standard of safety, comfort and reliability. So moving on to the question then, which is central of course to this appeal, what is plying for hire? At its simplest, but sometimes it's important to view these things simply, plying for hire by a taxi driver involves the taxi driver driving around or standing on the street in search of passengers who've not previously arranged a hiring. And that same activity by a private hire vehicle driver is unlawful. Can I take my lords to the case of Sales and Lake, please, which is in the authorities bundle at tab 17. Can I invite my lords perhaps just to read the head note on page 202 of the authorities bundle.
Yes.
Now, Section 7 of the 1869 Act at that time covered stage carriages, now referred to as buses. It doesn't anymore. Buses are now regulated by separate legislation. But Section 7 was the section in play in this Act. And if I could, in this Act, the Lord Chief Justice, Lord Trevethin, provided an entirely comprehensive definition of plying for hire. If one goes to the first page of the Learned Lord's judgment, on it's page 557 of the report, internal page 206. Toward the foot of the page, in my judgment, a carriage cannot accurately be said to ply for hire unless two conditions are satisfied. One, there must be a soliciting or waiting to secure passengers by the driver or other person in control without any previous contract with them. And two, the owner or person in control who is engaged in or authorises the soliciting or waiting must be in possession of a carriage for which he is soliciting or waiting to obtain passengers. Going on in the judgment, perhaps I could invite my lords to read on down to 2/3 of the way down the page, ending with the words as soon as the journey was over, just by the second hole punch in the page. So there's the soliciting or waiting to secure passengers without any previous hiring arranged. And the person who's doing the soliciting or waiting must be in possession of a carriage for which he is soliciting or waiting to obtain passengers. And what Lord Trevethan goes on to make clear is that the plying for hire is what occurs prior to the journey. So when a black cab is going along the street with its light on, it is plying for hire. When somebody hails it in the street and it recognises the hail and goes over to pick up the passenger, turns off its light, the plying for hire ends. Passenger gets in, there is the journey. After the journey is over and the passenger is dropped off, light goes back on, plying for hire recommences.
Yeah.
It's, and there's a direct analogy, we say, with what a private hire vehicle driver does when working off the Free Now app. Toward the bottom of the page, but further, in my judgment, on the findings of the learned magistrate, there is no evidence that this charabanc was ever plying for hire, because, for upon the facts found by him at the time when the advertisements and tickets were issued, which was the only time when Charabanc's London Limited was soliciting passage, no carriage was appropriated to the proposed journey. It's only after they'd ascertained the number of passengers that the company ordered this charabanc. Going on down the page, do my lord see where he says, just by the first hole punch on the page, the distinction I seek to make is, I think.
Yes.
Can I invite my lords to read to the foot of that page and the first paragraph on the next page, please?
Yes.
Now, with Lord Trevethan's definition of plying for hire, in that case, there's no difficulty in concluding that private hire vehicles working off the Free Now app are indeed plying for hire when they're driving round or parked up on the streets of London, waiting to secure passengers through the app who've not previously arranged a hiring.
I don't follow that, I'm afraid. If I saw such a vehicle outside the RCJ
Yes.
and got into the back,
Yes.
what would happen?
The driver, if he was strictly working off the app, might say, well, you can't do that.
Right. So he would say, surely, you've got to have a booking for pre-hire, albeit you can do it very quickly through an app.
Yes.
Whereas if I get into a black cab, that's not the answer he would give it.
Well, the black cab is plying for hire in a different way. The black cab is plying for hire with his light on, and he's looking for a hand raised in the street. Now, the private hire vehicle working off the app is waiting for a hail over the app.
I see.
I mean, that is because plying for hire can be achieved. Plying for hire is not only undertaken in one way. That's of the essence of it, my lord. So, for example, as referred to by Lord Trevethan, you can ply, and this is the case of Havill and Amos that I was going to take my lords to next. You can ply for hire by touting for customers. So, a private hire vehicle, whether or not he's also working off the app is beside the point. He can have his car parked up a side street, go to the front of a busy theatre where people are trying to hail cabs and perhaps some are not successful, and could go up to them and say, look, if you want a ride, I've got my car parked around the corner. And if they get into his car and off they go. He's touted. And that is plying for hire just as much as stopping when somebody hails you in the street or responding to somebody who hails you by use of the app.
Well, that's the whole question.
That's absolutely, my lord. It is the breadth of the concept of applying for hire, and it has properly to be understood not as an infinitely broad concept, but it has a breadth to it. It is not confined to a person just putting up their hand and hailing a black cab in the street.
And what about somebody who rings a number in a telephone book that's been put there by somebody, a private hire vehicle?
Yes.
Are they hailing?
No. That would properly be classed as a booking, a pre-booking. I apprehend the difference is this, and one has to focus upon the vehicle and the driver of the vehicle, because it is the vehicle that is plying for hire, obviously under human control. But if one looks at Section 7, it is the vehicle that is forbidden to ply for hire unless it is licensed.
A private hire vehicle might be out on the roads having done one job.
Yes.
And the phone rings in his vehicle and somebody says, "Are you free to come pick me up at X?" That's not applying for hire.
No.
But if his phone pings because it's an app, that is applying for hire.
Yes. It's a difference between a passive and an active actor. If he is just driving around in the hope that at one point his operator might ring him up and ask him if he would like another job, he is acting passively in that sense. On the other hand, if he opens the Free Now app, by opening the Free Now app, he is in doing so exhibiting his availability for hire to the world. And when I say the world, I mean anybody who is in possession of that app.
But what if his number is written on the side of his car?
Yes, that can well constitute applying for hire. Because by doing so, he is going round, and there is a good example, Rose and Welbeck Motors, that we can look at, where that's exactly the case. The taxi driver was sitting outside the station with the number on the side of his cab, and the court in that case had little difficulty in concluding that there was evidence that he was in that sense applying for hire, because he was doing it by having that number blazoned on the side of his cab. He was actively seeking, soliciting.
But both the Free Now model and the Uber model prohibit their vehicles from having any insignia on it saying this is a Free Now car, phone, whatever, or this is an Uber car, phone, whatever.
Well, they don't need it, my lord. They don't need it. It is the use of this app. It's had the most dramatic consequences on the market, and has led, as I've said, to the huge increase in the number of private hire vehicles working off these apps and the corresponding decline in the traditional form of the black cab industry. It's but the crucial distinction is asking whether the vehicle is plying for hire, whether the vehicle is doing anything that is be regarded as actively soliciting custom. And in our submission, working off the app, once the driver gets in his car and goes about the streets or parks up in a likely place and opens his app, he is immediately soliciting custom. He is saying, here I am available for hire.
But who is he saying it to?
He's saying it to anybody who has the app.
Yeah.
And on your submission, does plying for hire embrace any element that I am available for hire to any member of the public? Or can it be a subgroup of the public? In other words,
Well, it will obviously.
those who have the app.
Yes.
On your submission, it can include just a subgroup. You're
Yes.
still applying for hire, even though
Oh, yes.
not every member of the public can insist on your giving them a ride.
That's right. Yes. Yes, you apply for. Yes, I mean, so for example, if a black cab driving along with its light on, it's applying for hire to the people in the vicinity of his taxi.
Well, I understand that.
Yes.
But any member of the public who happens to be on that street at that time, as I understand it, is entitled
Yes.
to take advantage of that, this is what we call the cab rank principle.
Yes. Yes.
Applied to the profession.
Yes.
For example.
And with the app, the exhibition is yes, it's to the anybody who has the app. It's not obviously to those who don't. Cavill and Amos is that it's referred to, and we've seen it referred to by Lord Trevethin in Sales and Lake. It's worth, I think, just briefly going to it. It's at tab 16 in the bundle. This is the judgment of a very short judgment of Mr Justice Channel. And if I just take you to his judgment.
Bundle page.
Sorry, it's
201.
page Authorities Bundle, page 16. Tab 16, page 201. In the third sentence of the short judgment, in ordinary cases, in order there should be applying for hire, the carriage itself should be exhibited. It is, however, possible a man might apply for hire with a carriage without exhibiting it by going around touting for customers. This is, however, not this case. The appellant was touting for customers for his licensed carriage. He did not solicit customers to go to the wagonette in the first instance, and therefore there was no applying for hire with the wagonette. I mean, short, the facts were that the driver was touting for customers with his carriage at the railway station. His carriage wasn't large enough to take the entire party. And so they said, if you've got a bigger carriage, we'll come with you. So he took them to his stables where he had a larger carriage. And they took that. That was not licensed. But, it's a significant case in terms of making good the point I made about touting being unquestionably a kind of applying for one type of applying for hire. It's perhaps stating the obvious. If I could take my lords to the case of Gilbert and Mackay, which is in the Authorities Bundle at tab 20. And invite my lords to read the head note of that case.
I'm really sorry to keep asking, but if you can give me the page number.
Yes, 22. I'm sorry, you're electronically 228, my lord. Sorry. And if I invite my lords to read the head note, please.
this one doesn't appear even to have been cited in Reading and Alley.
I don't know. It was certainly cited in Cogley and Sherwood. It may not have been. No, my learned junior can check that while I'm on my feet.
I've just looked at the
No.
law report and it seems it wasn't. But,
I'm not sure I entirely follow the reasoning in this. I mean, insofar as it's a decision on its own facts, fine.
Yeah.
We're not bound by it anyway. But if one tries to analyse as a legal matter what's actually going on here, I'm not sure I follow this reasoning. Could it not be said that actually by requiring you to go into the office for the purpose of paying for the hire, that there is an insistence that there has to be a pre-booking?
Therein lies the importance of it in my submission, my lord. No, the pre-booking is common in most cases. In this particular case, the way that this company's contractual terms worked prior to the decision below, the contract for hire was to be made with the driver. But very often the contract for hire will not be made with a driver, but with an operator. But that doesn't matter if the vehicle in question was previously plying for hire. And that's what was happening in this case.
Well, I know that's what they said. I'm just not sure that it's right, I'm afraid. Because if somebody's standing in the street in his car,
yes,
and the passenger or potential passenger goes up to them and says, "Can you take me to X?" And he says, "Well, actually, I can't, because first of all, you've got to go to that office over there and enter into a contract with my operator before I can take you anywhere."
Yes.
Why isn't that an insistence that there has to be a pre-booking?
Because in a sense, my lord, it's with respect to asking the wrong question. The right question is, was the vehicle in question plying for hire prior to that point?
I see.
And that's Rose and Welbeck Motors.
well, let's do the cases one at a time. Rose and Welbeck is later.
Yes.
I'm still looking at Gilbert and McCarthy.
Yes. Now here you have the cars were lined up outside, so they were on view.
Yes.
If you wanted one, you had to go into the office to pay the fare, arrange the hiring with the person who we would now, I suppose, call the operator.
Yes.
You didn't know which car you were going to get, but all those cars lined up outside were, it was found, plying for hire. And there were no less plying for hire because rather than arranging the fare with the driver, you arrange the fare with the operator. And it'd be just the same. Suppose rather than the driver of a private hire vehicle acting unlawfully, touting for himself, had somebody who touted for him. A tout outside the theatre says, "Well, you know, I've got a driver around the corner with a car. If you pay me £10, he'll take you where you want to go." That would be no less plying for hire.
Let's try and break it down. If it weren't for the sign saying cars for hire, this prosecution couldn't have succeeded, could it? Because it was just several cars stationary in the street with no indication that they are for hire. Or do you say that doesn't matter?
Well, one's got to look at all. I mean, in this case, the cars for hire sign coupled with the cars out there on the street made it quite clear to the court that those cars were plying for hire. Whether absent the sign cars for hire, it might be made so obvious that that's what they were there for. It's possible. Each case of this kind of course, being case stated, there very much is a focus on the particular facts of the case.
But as we know, the industry at the moment has three types of service: black cabs, PHVs ordered through ride-hailing apps, and what you might call old-fashioned minicab offices.
Yeah.
And the old-fashioned minicab offices, you accept it. A customer phones the office, they say, we'll send somebody round. That's not flying for
No.
But suppose the offices do tend even now to have a physical presence. So if there is a shop saying such and such minicabs, maybe with a phone number, you can walk in to the shop, and there are 3 cars standing outside the office. Are those vehicles illegally applying for hire?
Well, certainly on this authority, yes, my lord. Yes, they are, because that is precisely the situation that the court was confronted with in Gilbert and Mackay.
Well, how can that minicab firm legally carry on business? What are the cars supposed to do? Must they go and wait somewhere out of sight of the minicab office?
It would seem on this authority, yes.
Right.
He says it's slightly remarkable to have a criminal offence where the commission of which can't be defined. There's no test.
Well, that's the importance of this case, my lord. Because these matters have all been dealt with. These cases have all been dealt with previously by way of case stated, for which there's no avenue of appeal to this court. Each of them has been decided on its own facts, and there has been no authoritative analysis of the position by this court. And this is that is why I apprehend the Divisional Court in this case said that the point was of considerable importance and granted permission.
Yes, so far as the law of precedent is concerned, we're not bound by any of these decisions.
No.
And this is really an appeal from Reading and Alley, is it not?
Yes. Yes.
On the point on the applying for hire issue, the Divisional Court in the present case said they would follow Reading and Alley. They weren't satisfied; it was so obviously wrong that they should overturn. And do you accept that, to all intents and purposes, the facts in Reading and Alley and the facts in of the case you're putting forward here are the same? There's no material difference between the Uber app.
There are differences, but not a difference that matters in terms of the broad principle, my lord. No.
Right. And we were mentioning criminal offences. I think it follows, doesn't it, that if your case is right, then every booking of a PHV made through an app in London,
Yes.
every journey in that booking, the driver is committing a criminal
Yes.
offence.
Yes.
And has been since
Yes.
since the apps
No,
were
it's
invented.
yes, it's a serious
Yes, it is.
serious matter indeed. What it would mean is that private hire vehicle drivers, if they wish to go on working off the app, would have to qualify as licensed hackney carriage drivers, and their vehicles would have to be licensed hackney carriages. Alternatively, they could forswear the app and work as it were, on telephone instructions from their operator.
Can I just delve into that a little bit more? We say every booking on an app. Many apps would enable me to book for taxi for, say, tomorrow.
Yes.
Would that constitute the driver applying for trade?
Well, no, it wouldn't, because as I understand the workings of the app, that is true pre-booking, because you are not then, when you pre-book on one of these apps, you're not pre-booking with reference to any particular vehicle.
Well, what probably happens is that all that means is that the signal will go out to those subscribing to the app shortly before the booking is due to be fulfilled.
Yes.
So in fact, probably the drivers will be doing exactly the same thing that they would have done if I asked for an immediate car.
Yes.
Only I'd asked for it some time ago, but they will get the ping on their app saying that there's a booking in a particular street in London. They won't be told it was made yesterday.
No,
So why isn't that applying for hire?
well, it is, because one's got to focus on the driver and the vehicle. And the driver and the vehicle, when he goes out in the morning, when he opens his app, he is then exhibiting his availability for immediate hire. And
But not to me. Not to me.
anybody, for anybody with the app, and anybody with the app, and if the job that comes into him is one that's been pre-booked, I apprehend it makes no difference. He was nonetheless applying for hire prior to receiving that request and accepting it.
So it's the opening the app and being available
In your vehicle.
applying, not accepting any particular booking.
No, and that's why the analysis of Lord Trevethin in Sales and Lake is so important, that the applying for hire is what happens before the job is accepted, before the hail is accepted. The black cab, to use a simple analogy, is applying for hire when he's driving his cab along with his light on. And the private hire vehicle driver is applying for hire when he is in his vehicle on the streets with his app open, showing that he is to the entire world that is in possession of that app, showing that he is there and available for hire.
He could actually be at home, but as long as, on your submission, as long as he's got his app on, he's applying for hire.
Well, if he's got, but if he's at home and if he doesn't have his vehicle with him, then he's not applying for hire.
Then he's not.
No, I mean, that's the value I apprehend of the definition provided by Lord Trevethin, that it's that two-stage test. You've got to be actively soliciting or waiting for a customer, and you've got to be in possession of a vehicle with which to fulfill the hiring if it comes your way.
Of course, the vehicle isn't inside the house, but suppose that he's at home and his PHV is immediately outside
Yes.
the house.
Yes.
Is he applying for hire?
Yes.
He switches on the app.
Yes.
Okay.
Yes. Provided he's got the vehicle to fulfill.
Yes.
He's unlike. It depends where his house is, I suppose. He's if his house is on the Strand, then he's likely to get a job. If his house is in a very remote area, away from where people are likely to want rides, he won't. But the whole point about it is that in operating the private hire vehicle drivers, what they will do, obviously, in order to secure rides, is to position themselves and their vehicles in places where there is likely to be a high demand.
The minicab driver who puts his phone number in Yellow Pages and opens up his mobile phone in the morning, gets into his car, that's not applying for hire.
No.
The minicab driver who puts his mobile phone number on a website, that's not applying for hire. It's not applying for hire. But it can't matter whether his number is on in any other pages or whether it's on a website. Can it? You know the next
Yes.
is,
No.
what matters what his mobile phone is on an app, what his mobile number is on an app.
The difficulty is, of course, that it is unlawful for a private hire vehicle driver to accept a booking himself, and this we established below. The booking has got to be made with, and the contract has got to be entered into with the operator, so that a private hire vehicle driver who put his phone number on the yellow pages and in that way solicited custom would be acting unlawfully. And I think our argument...
You have one-man companies, can't you?
Yes, yes.
So you have somebody who sets up a minicab company.
Yes.
And he is both the operator and the driver.
Yes, yes, if he's qualified as an operator.
Yeah. So,
yes.
And so he puts or the operator puts the number on a website.
Yes.
Or then puts it on an app.
Yes.
And it's very hard to see where one draws the line here.
Yes. No, we're dealing with fine distinctions. We're dealing with fine. There's no question about it, my lord. But that they are fine distinctions does not mean they're not important distinctions. And the distinction that we seek to draw is between the private hire vehicle driver who is actively soliciting custom from persons with whom there is not a previous hiring has not been arranged, and the private hire vehicle driver who is, as I put it previously, passively waiting for bookings to come his way through his operator. Yeah, that's my learned junior makes a very good. The legislation on private hire vehicles requires the booking to be accepted not in the car. It's got to be accepted at a place called an operating centre.
Yes. Yes.
So that it's good to tease these things out by.
But it can be
sort
done
of probing.
electronically.
I'm sorry, no.
Electronically, it doesn't have to be laboriously done through calling somebody.
Well, no, but the operating centre has to be there has to be an address. It can't be in the ether. An operating
you can't book a private hire vehicle through the internet.
You book it through the internet, but there has to be a physical address at which the operator is based, where I apprehend the computer is based. That accepts.
It can all be done pretty much instantaneously, can't it?
Yes, yes, but the fact remains that if the operator is also the driver, which is the point that my lord was asking about, then his operating centre would have to be his home or an office that he had. That would be his operating, and it is there that the.
I don't think in current days of technology that would be any great problem with it. I mean, it would all be done electronically, and it would go through.
Yep.
No doubt, go through a computer at somebody's home and then out to their mobile phone. I mean, and pre-booking would be a matter of milliseconds, wouldn't it?
Yes.
And we're talking about. I mean, the problem is technology has enabled all these things to be done instantaneously or within a scintilla.
Yes.
To the extent that, is there any difference between booking a private hire vehicle through that route and booking it through an app?
Well, the difference is that with the use of the app, it is the driver who actively solicits by being in his vehicle and opening his app.
As opposed to the operator.
Yes.
But why are not the employees of the minicab company also soliciting by opening their mobile phone?
Because the mobile phone isn't sending out an invitation. It's not sending out that by opening the app, you are sending out a message to the world. That is how these little car symbols appear on the app.
But that goes through the operator of the app. It doesn't go straight directly to individuals. It goes through the company.
Well, it's by the electronic wizardry that lies behind these apps. When a driver, suppose a private hire vehicle driver is out on the Strand, opens his app. If I leave the court and open my app, I'll see the image of his vehicle out there on the Strand.
But that's, I think, in a way that picks up a point my lord made earlier, which is it's only to other people, to people who are subscribed and have opened the Free Now app.
Yes.
Because, in fact, it doesn't go out to members of the public. It goes through the operators of the app so that they then transmit that to the people who are subscribers to their app and have opened it and made a request for a taxi.
Well, it isn't. I apprehend, my lord. It is effectively an immediate. By opening the app, the driver is immediately saying to the world, "Here I am." Obviously, the world.
Well, forgive me, he really isn't doing that. What he's actually doing is saying to the operator of the app, "Here I am," and the operator of the app then tells those people who subscribe to the app that he's available. And that's actually what's happening. I agree, it's all happening so instantaneously but it's not like the taxi driver driving along the Strand saying, "Here I am, everybody." The driver who subscribes to the app notifies the operator of the app that he's available, and the operator of the app then tells its subscribers that taxi driver is one of a number available.
Well, my lord, that's, as it were, giving in those circumstances the operator a personality. It's automatic. It's automatic that when he opens the app, the image of his vehicle and its availability appears instantly.
Well, I think that those drivers who subscribe to it probably and pay for it probably do subscribe to it a personality. It's not nothing, is it?
Well, the fares, as I understand it, there's a division of the fare. I don't think they have to pay for it.
But in terms, the operator, in the case of Free Now, is Transopco Limited. Certainly, it was a very important point in the Uber litigation that Uber London Limited was the operator and had been granted a license as being a fit and proper person to do the work. They were claiming they were no more than the humble local agents of a Dutch company for intellectual property purposes.
Yes.
But that was logically incompatible with their saying that they're a fit and proper person to do the work. So under the PHV London Act, there must be an operator,
yes,
whether it's a company or a one-man band.
My lord, yes.
Which is itself licensed as a fit and proper person.
Yes. And in this case, of course, it's Transopco.
Yeah.
Yes.
I mean, you may come to this later, or you may want to go through the case law and then come back to it. But the point I think my lord is putting to you is that the driver is not saying to the members of the public, "Here I am, I'm available for hire." He is saying to Transopco Limited. Here I am.
Well, that, my lord, is a point with which we can't agree, because we say that by opening the app, he is automatically, his availability is being publicized by him. He is, by opening his app, he is, with his vehicle, he is doing all that he can do and all that he needs to solicit custom.
Let's imagine that he's driving on the Strand and he's got his app open.
Yeah.
And he drives past Mr. Smith, who is standing there very much hoping to get a ride. He's not saying anything to Mr. Smith, and Mr. Smith doesn't know he's available. He'll drive straight past him. So he's not applying for hire to Mr. Smith. On the other hand, Mr. Jones is there with his Free Now app open and is asking for a ride. And because the driver has told, through his app, has told Transopco that he's available, Transopco is telling Mr. Jones that that vehicle is available, and therefore they connect. And so you cannot in any sense say that the driver is touting to the public as he drives along. It is a private arrangement because they have mutually subscribed to an app through Transopco, and the communications between them go through that app. And unless the driver is paying Transopco and the member of the public is paying through the app for that service, they will not connect. And so it seems to be a private booking, not one which is made but directly by touting to members of the public.
My lord, there is, with every respect, a certain artificiality in that analysis. I say that with the greatest respect. When he when he opens his app, he or she, one could say, oh well, he's not in so doing soliciting custom. But if you were to ask him what he's doing when he opens his app, he'd say, well, I'm hoping for customers. That is how he goes about his soliciting. And when a person opens their app, somebody who's got the Free Now app, what they're doing is looking for a ride. They're looking for a car and a driver who are available in their vicinity.
There's no difference than a modern day version of ringing up the minicab firm, and the minicab firm rings the driver and says there's somebody standing on the Strand wanting a drive.
Well, the difference I've sought to make, and this is where I say there is this fine line, but it's an important one, is between the driver opening the app and actively in that way soliciting custom, and the driver who is passively driving along on the off chance that his operator will ring him up and offer him a job.
Well, when he clocks on in the morning, he rings the office and says, right, I'm available. Why is that different?
Because his vehicle, as he drives, so to take the example of him driving along the Strand, neither Mr. Jones nor Mr. Smith will be aware that he is available for hire. He's not, as it were, exhibiting his availability to anybody. He's in a different position from the private hire vehicle driver who is exhibiting his availability, albeit only to Mr. Jones, because Mr. Jones has got the app and Mr. Smith hasn't.
Well, it's only a speeded up version of 2 phone calls, isn't it?
Yes, but
it's speeded up very dramatically.
Well, it's qualitatively different in our submission, in the way I've sought to explain. It's one. The example we've just essayed perhaps describes it best of all. That the car driving along the Strand with its app open will be exhibited to Mr. Jones, perhaps not to Mr. Smith because he doesn't have the app. But the private hire vehicle driver who's waiting on the off chance of a call from his operator, He's not exhibited to anybody at all. That is the fine distinction that we say is all important.
And not that exhibited is a word in the statute, it's a word in the case law, but you say that in each of the drivers in the vicinity of, was it Mr. James is the one with the app. Each of the drivers in the vicinity whose vehicles are represented by a rectangular blob when Mr. Jones switches on, each of those is soliciting the custom of Mr. Jones, and each is exhibiting his vehicle to Mr. Jones.
Yes. By using the app, each of them is applying for hire, each of them is soliciting for custom from people who have not previously arranged a hiring.
Is the physical depiction of the vehicle critical to your argument? What would it be different if what the app said was there are 17 vehicles within 3 minutes of your the place where you're standing?
No, I don't think it would be different, my lord. No, it wouldn't, because it would still be exhibiting in the sense that I've used it. He would still, but he would become one of those 17 by being in the vicinity and by working off the app.
Can I ask you, if my lord has finished, can I ask you about a different
Yes, my lord, please.
strand to this, which is intriguing me at least, and that's to what extent, if any, there is an element of obligation on the part of the vehicle if it's plying for hire. So in the examples that we've just been discussing, Jones and Smith are on the Strand hoping to get a taxi
Yes.
or get a ride. On your submission, is the driver under any obligation to take the first ride? Or can he say, well, actually, I've just had a phone call saying there's a job I can do going out to the airport, so I'd rather do that. Is he allowed that choice? Or
Yes. Oh, yes. Yes.
Right.
Yes. Soliciting for custom, in this case, as in any other walk of life, I apprehend, unless one's talking about members of the bar, I suppose. If you're offered a job, you don't have to take it. You can solicit for work, and if the work is offered to you, you can say, no, I don't like the look of that. It's the same with a black cab. In fact, there is the idea of compellability, but compellability only occurs when the driver has stopped and the passenger has got into the cab. So that if a black cab driver is driving along with his yellow light on and he sees somebody hailing him on the street who doesn't like the look of for whatever reason, he's not compelled to stop. He can drive on by. Similarly, a private hire vehicle driver, when responding to somebody on their app presses ride now and the ride is offered to that private hire vehicle driver on the app, he doesn't have to accept it.
Well, Uber, I only know this from the case, have quite an elaborate system of penalising drivers who don't, who turn down.
Yeah, that may be.
I don't know about Transopco. I had a question of fact, which, if you can answer, that's very helpful, and if not, I hope Mr. Colvin can answer. When the Uber app, as it were, pings a driver and says that there is a passenger waiting outside the Royal Courts of Justice, WC8 2LL, it doesn't tell the driver where the passenger wants to go, even though it knows. And so in that respect, similar to the black cab driver.
Yes.
It's not allowed unless the journey is going to be more than whatever it is.
Yes.
6 miles.
Yes. From
It's not
Charing
allowed
Cross.
to say, I'm not going to take it.
Yeah.
Is that the same, is the position the same with TransOpcat? Does the free now driver who is pinged by the app know where the passenger wants to
My understanding, it doesn't, is it?
Can I take instructions? I think it changed because drivers were somewhat disadvantaged. They'd take a ride and suddenly they were made to drive an hour in the other direction from their home.
Yes.
I believe it changed, but it's a good couple of years ago. Can I take instructions?
Yes.
I'll tell you after lunch.
That would be very helpful.
Thank you.
Yes. Right. Back to you.
Thank you.
We got as far as Gilbert and Mackay in 1946, and then
Yeah.
we've been lobbing questions at you ever since.
No, my lord, no.
Do you want to go back to the case law?
Yeah, I ought to go to Cogley and Sherwood, my lord.
Yes.
That's at page 230 in the bundle. It's tab 21 in the. Maybe I could be lazy and invite my lords to read the head note first.
Yes.
We go to the judgment of the Lord Chief Justice, Lord Parker, my lord. It's on in the reports, page 323, the pagination of the bundle, page 242. And if I could invite the court to at the final paragraph beginning, the court has been referred, and if my lords would read from there over the page to the end of the last full paragraph, ending with the words public to be conveyed in it, please.
How far did you want us to
Just to the end of the paragraph, the second full paragraph on page 324, ending with the words driver invites the public to be conveyed in it, my lord. Now, two points of importance there. Lord Parker noted that because of the nature of the cases that were being heard, I'd say cases by way of case stated, it's clearly inadvisable for the court to attempt to lay down an exhaustive definition. So he appreciated that, obviously. And then in the next paragraph, this is of considerable importance in our submission. Approaching the first thing that strikes one is that the Act is dealing with carriages plying for hire, not with persons carrying on the business of letting out carriages. It is the carriage that must ply for hire, and though a human agency must clearly be involved, the Act is directing one's attention to the carriage under consideration and posing the question, is it plying for hire? He went on to consider a number of previous cases, and if one turns the page, page 325 in the report, 244 in the bundle, bottom of the page, in the ordinary with therefore I should, apart from authority, have felt it was of the essence of plying for hire that the vehicle in question should be on view, that the owner or driver should expressly or impliedly invite the public to use it, and that the member of the public should be able to use that vehicle if he wanted to. Looked at in that way, it would matter not that the driver said, before you hire my vehicle, you must take a ticket at the office. So at that point in his judgment, the learned Lord Chief was identifying the need for exhibition, but the type of exhibition he was talking about was the vehicle being on view.
On your submission, are the words the public of importance or not?
The public to use it. I think this goes back to the point I was making, my lord. I'm in terms of the Free Now app, one is talking about those members of the public who have access to the app. Clearly, it's not everybody in it.
That's slightly difficult to interpret in concept of that a member of the public should be able to use that vehicle, because that's mainly referring to any member of the public.
Well, in that context, it is, my lord. Yes, it is. But the concept of exhibition, the concept of plying for hire, is in our submission not confined to that. So that there can be applying for hire. Take, for example, touting. In touting particular individuals, it's the individuals who happen to be outside the theatre and the ones who the tout approaches.
Sorry to go back to a question I asked you,
No.
last you before, but do you accept that as this is a criminal act, it has to be construed restrictively?
I don't know whether one would say it's got to be clearly defined, and then but restrictive. No, my lord, I wouldn't accept the notion of restrictive. It's got what one has to strive for. What the courts in all of these cases have strived to achieve is an understanding whether in the particular circumstances of these cases, they all being case stated, there was evidence before the justices which justified or did not justify the decision that there was applying for hire. Now on appeal to this court, the question can be stated rather more broadly, and we can look to this court to provide a more authoritative definition, which has to. What is essential, of course, is clarity in the matter.
But it would apply retrospectively, wouldn't it? Because it would be saying that activities in the past were criminal.
Have been, yes. What this court, if persuaded by our arguments, would do is to make appropriate declarations, and then it would fall to the regulator to ensure that the private hire vehicle industry in London henceforward was conducted lawfully, and that's what happened with regard to the operator issue. The court below concluded that this company, and actually the same was true for a lot of other companies, were conducting their business unlawfully. The court below declined to quash the decision to give Transopco an operator's license upon Transopco's assurance that it would alter its method of operation in accordance with the court's declaration. And that is precisely what we'd invite this court to do.
But this is slightly different, because this is inviting the court to say that individuals who at this very moment are going about what they may have thought perfectly lawful business are acting criminally.
Yes.
Based upon what one at best might say is an open textured interpretation of the phrase.
Yes. What one is looking for is the clarity, and that is essential in order that operators and private hire vehicle drivers may have a clear understanding of what they can and cannot do. Yeah.
Well, you have made it clear enough in answer to the question I put to you earlier. It must follow that any PHV, any PHV driver who switches on his app and goes out for a day's work is on each occasion committing an offence.
Yeah.
Where I find it difficult to draw the line is why you say that such a driver is exhibiting his vehicle to the public or a section of the public in a way that the more traditional minicab driver, not using an app, but whose company has got as far as having a website as well as a phone number, so somebody can go to the website, give their details and say, I want a vehicle now. Why you say that's completely different from doing it through an app?
It's because when doing it on the app, as Lord Parker said in Coghlan Sherwood, you focus on the driver and particularly the vehicle and what they are doing. Now, in the case of the operator who's got a website or a number and name in the yellow pages and whatever, his driver and vehicle, the driver and vehicle in that case, as they are out on the streets, are not doing anything positive to exhibit their availability for hire. It's the distinction that was identified in Gilbert and Mackay. In that case, the focus in that case was, in terms of whether there was plying for hire, the focus was particularly on the vehicles that were on view outside the office. It's those vehicles with their drivers in their seats that were held to be plying for hire.
In Cogley, which you've just taken to, as I understand it, it's critical to the decision that the vehicles were nearby, but you couldn't just walk up to them. Indeed, I think at one terminal there wasn't physical access except via the office, and so the court holds no exhibition of the vehicle to the public.
In the sense that they were not on view. Yes, yes.
Do you say that if the app said there are 17 vehicles in the vicinity, then all 17 drivers are committing the offence?
They're all applying for hire.
Because they're all on view.
Yes. And actually, my lord, when one considers it, all of these cases have been criminal cases. All of these cases stated that in all of them, the question has been whether drivers and their vehicles doing what presumably, in some cases at least, they supposed they were perfectly entitled to do, were in fact committing criminal offences. And in many of these cases, it was concluded by the Divisional Court that they were.
And in Cogley, at page 326, Lord Parker says it's of the. He refers to Gilbert
Mackay, yes.
and Mackay without saying very much what he thinks about it, and says at the end of the paragraph, for myself, I think it is of the essence of plying for hire that the carriage should be exhibited.
Yes.
Right.
Yes, I was going to invite my lords to read the paragraph begin at the foot of page 325, beginning in the ordinary way.
Yes.
And over to the end of the last full paragraph on the next page, beginning the paragraph beginning here, I think.
Yes. The very bottom of 325, the member of the public should be able to use that vehicle if he wanted to. Does that apply in the present case? I mean, the free now passenger or Uber passenger can't say I want that vehicle, that blob halfway up the Strand.
No, but no more than could the passenger in Gilbert and Mackay. In my submission, it is not essential that you should be able to identify the car you want. That, because again, that is, if one isn't careful, it's very tempting to look at this from the, as it were, down the wrong end of the telescope. One's focusing one's attention, one has to focus one's attention on what the driver and his vehicle are doing. That's what matters. If the vehicle and his driver are soliciting custom, as we say they are through the use of the app, that is plying for hire.
Well, it appears that, so we have covered this, it does appear that this reasoning views exhibiting for hire as to the public.
Yes.
To any member.
Yeah.
Which of course isn't the case.
No, but I think with respect, one has got to be quite careful with these cases because they all are all fact specific. In this case, it was what we now know as Heathrow Airport, and the limousines were away from the terminal, but in the terminal there was a booking desk, so a person could go up to a booking desk and book a car. Well, he would have no idea which car he was going to have, of course. But the reason why the Divisional Court in this case found that there was no plying for hire was because they could not identify any activity on the part of the car or the driver which amounted to exhibition in the sense that they were. And they were interpreting exhibition in quite a narrow sense of the vehicle being on view, but that was perfectly adequate for the purposes of this
But on
case.
view to the public. But
Yes.
on view to the public.
Yes. But so but the point I was going to go on to make was when we looked at the passage that I invited my lords to read, Lord Parker says, there are, however, some cases that point to a different conclusion. And he refers to Gilbert and Mackay. Also refers to Cavell and Amos, where he goes on to say, in ordinary cases, in order there should be applying for hire, the carriage itself should be exhibited. He thought, however, that a man might possibly apply for hire with a carriage without exhibiting by going about touting for customers. So he without for a moment explaining either why, in his view, that does not amount to applying for hire, which would be a strange proposition in my respectful submission. But he continues to say, for myself, I think it's of the essence of applying for hire that the carriage should be exhibited.
I read that as the Lord Chief Justice not agreeing with Mr Justice Channel.
Well,
am I wrong?
I apprehend he doesn't. He doesn't say why. He certainly, if he is this, he's certainly maintaining that, from his point of view, exhibition is critical. Now, in my submission, one can actually, the two are not necessarily at odds, because one could regard the activities of a tout as being tantamount to exhibition. The tout is effectively, to the people he approaches, exhibiting the availability of the car.
In a sense, Mr. Fraser, you've now come to Cogley, which I think is the last case, or the last case of significance before Reading and Alley. It was Rose and Welbeck, I suppose. But as I said earlier, none of these cases is binding on us.
No.
And the real question for us is whether Reading and Alley, by which time at last one's come to the world of the app and
Yes.
the 21st century, whether Reading and Alley was rightly decided.
Yes.
But you take your course. Do we want anything more out of Cogley?
Well, what I did, yes, if I may, my lord, just to say that he then goes on to the case of Griffin and Grey coaches. So it's said, however, he says that the cases concerning stage carriages, in particular the case of Griffin and Grey coaches, to which I've already referred, force one to a different conclusion. Now, if I could invite my lords to read over the page where he begins in Griffin's case, because we haven't gone to Griffin and Grey coaches, but to just read from there, please, to the foot of the page.
Yes.
Now, what's significant about that, my lord, is by this stage, having looked at Gilbert, Mackay, Cavell and Amos, and then Griffin's case, that at the foot of that page 327, there is something to be said for the view that they are exhibited in the sense that I have indicated, even though a particular vehicle is not on view when the ticket is bought. What Lord Parker is forced to conclude is that the term exhibition is not to be understood in a narrow sense of being exclusively confined to the vehicle being on view. But he interprets it in a broader sense to square his approach with the approach that the Divisional Court took in Griffin's case. And similarly, one can square it with Cavell and Amos in the way that I suggested to my Lord Justice Singh. And that's the importance of this case in my submission, to appreciate that this notion of exhibition, which in Sales and Lake, they talk about soliciting. Well, to solicit, you have to exhibit. You've got to somehow bring your vehicle to the attention of potential customers. That's what solicitation involves. You do that by exhibiting it, and you can exhibit it in a number of different ways. And one sees the same notion when one goes in the same judgment to the judgment of Mr. Justice Donovan, as he then was, at the foot of page 329, that's 248 in the internal pagination of the bundle. Four lines down in the final paragraph. Like my lord, I do not regard the decision in Griffin and Grey Coaches Limited as antagonistic to this view. There it is true that the charabanc was not on view at the time the passenger booked his seat, but the court was dealing with a regular service at regular times along a regular route. One can, I think, exhibit a vehicle such as an omnibus or a charabanc just as effectively for the purpose of hire in this way as any other. By these means, it will come to the notice of prospective customers, which, after all, is the object of exhibition. And I, as it were, emphasize that last sentence because that is exactly what we say a private hire vehicle driver is doing when he opens his app and is with his vehicle. He brings it to the notice of prospective customers, which, after all, is the object of exhibition. And yes, the customers are confined to those with the app. But Molina Jr. made a valuable point on this, I apprehend, because where going back to Lord Parker's judgment at the foot of page 325, where he says the owner or driver should expressly or impliedly invite the public to use it. Of course, in this case, it wasn't the public at large who were being invited to use it or would be invited to use it if those limousines had been on view. It was only the people who happened to be at the airport being private land. So I think
it's always the case.
Yes, it's always the
Only
case.
People in the vicinity.
Exactly.
But
Exactly.
it's anyone who's in the vicinity.
Yes.
Not, what if they're only being made available to members of an executive club of a particular airline? Would that be exhibiting?
Yes. Yes. The members of the it'll never be the entire world. It will only be those who are, depending on the mode of exhibition. If it's touting, it'll just be those individuals who happen to be outside the theatre. If you're exhibiting through use of the app, it'll be the people who have the potential customers who've got the app. If it's the yellow light on the taxi, it'll be the people who happen to be in the street down which you're driving. So it's the public in the sense of those who are, as it were, available to be solicited by the means of solicitation that you're choosing to adopt.
Well, there is a distinction, isn't there, between soliciting to members of the public, namely those members of the public who are in the vicinity, and soliciting a select group of people who may be in the vicinity or otherwise, and thereby not soliciting the general public.
I'm not sure, my lord, that it matters that you have, as it were, restricted the, think in terms of potential customers. If you are soliciting for custom, the fact that you have confined your solicitation to a particular group.
I think the reason is because it goes with the fact that people you're soliciting are people who have subscribed to the same service that you have subscribed to, and that your engagement goes through that route. So you're not saying to members of the public generally, I'm available. You're saying through the app operator, you're saying to the people who subscribe to that app, I'm available.
Yeah.
It seems is at least arguably different.
It's a feature of this form of solicitation. Yes. Yes. There's one more case that I'd invite my lords to consider before we get to Reading, and that's the Eastbourne Borough Council case.
Sorry. Can we look at one passage in Cogley, which we haven't, I think, so far looked at? It's at page 250 of the bundle.
Yes.
In the judgment of Mr Justice Salmon.
Yes.
And just about 5 lines down that page.
Yes, my lord.
He says, but for authority, I should have thought that a vehicle applies for hire if the person in control of the vehicle exhibits the vehicle and makes a present open offer to the public, an offer which can be accepted, for example, by the member of the public stepping into the vehicle.
Yes.
I just invite your submission on whether he's right or wrong about that principle.
Well, he's not, with respect, right if that is to be regarded as an exhaustive definition of applying for hire. That is one instance of applying for hire, and it's perhaps with reference to the way in which a black cab operates when applying for hire.
Thank you.
Now, Eastbourne Borough Council and Stirling, my lords. This is an out of London case. It's, as I said, tab 26, internal page 281 in the authorities bundle. It was an out of London case where there's different legislation. It's governed by the Town and Police Clauses Act 1847, which forbids unlicensed carriages from applying for hire in any street. The words "in any street" are not found in Section 7 of the 1869 Act, as we know. However, the issue in this case was whether the applying for hire was in the street, where the private hire vehicle driver in question was positioned on private property adjacent to the street. And in giving his judgment, Lord Justice Pill, having referred to the analogous case of Smith and Hughes, said at paragraph 20, the vehicle is applying for hire in the street if his vehicle is positioned in circumstances such that the offer of services is projected and addressed to members of the public in the street. If I could take my lords to, in the authorities bundle, it's page 286, and invite my lords to read paragraphs 18, 19 and 20.
this is the taxi rank in a station 4.
Yes, yes. So it's on private property.
And the defendants are trying to say ingeniously, aha, it's not a street. And that was their only point.
That was the point. That was the narrow point. But it's the notion the driver is applying for hire in the street if his vehicle is positioned in circumstances such that the offer of service is projected and addressed to members of the public in the street. It's the notion of offer of services being projected and addressed, which is, we say, precisely what the private hire vehicle driver does when he opens his app. He projects and addresses his offer of services to members of the public who have the Free Now app. And we'd say that private hire vehicle drivers whose drivers are working off the app are unquestionably flouting the purpose of the 1869 Act, which, as we've seen, was to ensure that only licensed hackney carriages driven by licensed hackney carriage drivers could apply for hire, because, in the words of Mr Justice Salmon, as he then was in Cogley, in such cases as these, the member of the public knows nothing and has no time to make any inquiry about the vehicle or the standing or indeed the identity of the owner. And he said it's not surprising in such cases Parliament should make arrangements that the vehicles which so apply for hire shall be of a certain standard of safety and comfort upon which a member of the public can rely. When a person using the Free Now app requests a ride now from a private hire vehicle waiting or cruising somewhere in the vicinity, not licensed or subject to the same strict regulatory requirements as a licensed taxi, and a private hire vehicle arrives to pick her up a minute or two later, she knows absolutely nothing. Nothing, and has no time to make any inquiry about the vehicle or its standing or indeed the identity of the driver. And in our submission, the parliamentary purpose underlining the 1869 Act is thereby undermined, just as surely as it would have been if such a licensed private hire vehicle had responded quite unlawfully to her hailing it by raising her arm in the street. My lords, in our submission, app-based hailing of private hire vehicles has facilitated unlawful plying for hire by private hire vehicles on an industrial scale. Since a licensed private hire vehicle may not be of such design and appearance as would lead any person to believe that the vehicle is a London cab, and the private hire vehicle legislation, the 1998 Act, at section 7, subsection 2, subsection 3, states that it cannot be of such design and appearance as would lead any person to believe the vehicle is a London cab. Prior to the advent of the ride-hailing apps, it was difficult for private hire vehicles unlawfully to apply for hire, even if they sought to do so, since there was nothing about their appearance that would lead a person to hail them in the street by raising an arm as they approached. Now, that difficulty has been removed by the advent of the ride-hailing app, by which a private hire vehicle driver can plainly exhibit his vehicle's availability for immediate hire by any user of the app. And, my lords, the description of the device by Transopco itself as providing a ride-hailing service is telling and is precisely correct. Can I invite my lords just to go in this supplementary bundle?
Sorry, just pick up on something you said.
Yes, my lord.
Can we again go back to the pre-ride-hailing app age? As you say, PHVs in London have been regulated since 1998. Is it at the moment illegal for a PHV to drive around saying Matthias cabs or whatever it may be with a phone number, and you phone, the driver isn't allowed to allow you to step into the car, can't just wave it down, but is that illegal applying for hire if somebody drives around with a phone number?
Well, that's been found to be so in the Rose and Welbeck Motors, which is one of the cases we haven't looked at. But perhaps we
All right. Well, let's look at it if you like.
we ought
It's
to go.
prior in time to Reading and Alley, isn't it?
Yes, it is.
So, tab 23, page 255.
No. Perhaps if my lords consider the head note, and then you can go to the relevant passage.
Right.
So, was there a case to answer? At the foot of, in the pagination for the bundle, page 260, Lord Parker, who of course had given the leaving judgment we've looked at in Cogley and Sherwood, said, in my judgment, there's no real difference between expression taxi and cab, and in the particular circumstance of this case, it seems to me that any tribunal would be bound to hold that this vehicle was exhibiting itself as a vehicle for hire. Therefore, the case ought to be remitted to the justices. And quite, Mr Justice Wynne, giving the second judgment at the foot of page 261 in our bundle, quite pithily at the very lowest, he says, the evidence in the present case discloses behaviour and appearance on the part of this vehicle which amounts to an invitation get in touch one way or another with my owner and see whether he's willing for you to take me as a vehicle which you are hiring. Can I just, whilst on this case, can I invite my lords also to look at page 259 in the bundle, back into the judgment of Lord Parker, where he makes reference to Cogley's case. About halfway down the page, he says, again, in Cogley's case, this court held that it was essential before one could say a vehicle was applying for hire, first, that it should be exhibited or be on view for the public. Secondly, that it should be while on view expressly or impliedly solicit custom in the sense of inviting the public to use it. The fact that if those conditions were proved, a ticket had to be obtained from an office or a booking made other than through the driver was immaterial. It's right to say that a further possible question, namely what was to be the result of the obtaining of a ticket or booking involved a vehicle other than that on view, was left open. However, reference however, was made to Gilbert and Mackay and the argument in Frynett and Clark, which cases suggest that at any rate in certain circumstances that fact would not of itself prevent a finding that the vehicle in question was applying for hire. That the vehicle in the present case was on exhibition in the sense that it was on view to the public's undoubted. The real question, it seems to me, is whether a prima facie case was made out that the vehicle in question was impliedly inviting the public to use it.
I have to say, speaking for myself only, I have some doubt about whether this is correct. Because analysing it as a matter of first principle,
Yes.
The phrase impliedly inviting the public to use it begs some questions with respect. And the earlier examples which are given on that page, that would it be different if you have to have a booking, or if the booking involves a vehicle other than the one on view? Well, it seems to me, at least as a matter of principle, that that could be two very crucial differences, which distinguish applying for hire from something where there has to be a pre-booking, and the driver isn't saying this vehicle is going to be for hire. It could be some other vehicle.
It's again, well, I think my lord's absolutely right. I mean, the focus for applying for hire has to be not on the booking arrangements that may be made. Applying for hire is focused on the activity of the vehicle and its driver before a ride is organised, before there is a hiring. Is at that point, is the driver and is the driver with his vehicle applying for hire? Is he soliciting custom by his action, by his activity? And the court in Rose and Welbeck concluded that it was they only had to conclude that there was a prima facie case in that regard, but they thought that by lurking, by standing outside the station close to the black cab rank with those details on the side of the car, they thought there was a prima facie case that the driver and that vehicle were doing just that.
Well, the location in which the driver was doing it is emphasised at the top of page 260 by Lord Parker.
Yes.
It says it's equally important.
Yes.
Where does that take us? Is this, you say this case is authority for the proposition that any minicab which has on it a phone number is one whose driver is committing a criminal offence?
Well, certainly on the analysis of the court, it's not our case, of course, but on the analysis of the court in Rose and Welbeck, by so doing, the driver may well be applying for hire. Oh, well, one has to ask oneself, what is the purpose of exhibiting the phone number? In this case, it was Welbeck Motors with a phone number.
Yes.
And the car is there. It is an implied, as the court held, it was an implicit invitation to members of the public. It was it was a solicitation in that sense to members of the public, or members of the public who happened to be in the vicinity of the station at that time, people coming off the train.
I may be misunderstanding what the Lord Chief Justice is saying here, but on the face of it, what he says in this case appears to be inconsistent with what he had said in Cogley at page 245. Because there he gave the alternative example at the very top of page 245, where the driver says, "You cannot have my vehicle, but if you go to the office, you will be able to get a vehicle, not necessarily mine."
Yes.
So he appeared there to be drawing a contrast between immediate hire, which is applying for hire,
Yes.
and saying to someone, "You can't necessarily have me, you've got to make a pre-booking. You may get a vehicle, but it won't necessarily be mine."
Yes. No, my lord. My lord is correct to identify that apparent tension.
All right, thank you.
So going back, before we leave Rose and Welbeck,
Yes.
what do you say is the significance of the location where the driver was? You stayed for some 50 minutes at a place where buses turned round, and when he was required to go away, he goes straight back to the same place. Now, is that important, or is that just by the by?
Well, my lord, I mean, all of these cases, they're all criminal cases. They're all fact sensitive, and that was a critical part of the, as it were, the actual matrix of that particular case. And that's all the Divisional Court had to deal with there. I apprehend it's the point actually that Lord Parker was making at the beginning of his judgment in Cogley and Sherwood. It's unnecessary that he talks about these cases all come before the court on case stated, and the question whether a particular vehicle is applying for hire being largely one of degree and therefore of fact has to be approached by considering whether there was evidence to support the justice's finding. In those circumstances, it was unnecessary and clearly inadvisable for the court to attempt to lay down an exhaustive definition. Now, one's got to look at all these cases with that firmly in mind. And it does mean that often when the judgment in each case is specific to the facts of that case, and one's got to be very careful in drawing out a general theme. That in my submission, that's, with respect to my lords, that's the task that falls to this court, and it's possible to do so. I hope in the way for which I'm contending. That
Yes.
one looks at the driver and the vehicle, and asks whether that driver with his vehicle is soliciting for custom from people who have not previously arranged a hiring. And a clear example of that in our submission is when a driver opens the app and thereby exhibits his availability for hire to all those who have the app.
Yes. All right. Are we now coming to?
An echo in the quarter.
Does that bring us to Reading and Alley?
Can I can go straight to Reading and Alley. I did want to just take my lords to one page in the supplementary bundle.
Yes.
Because if my lords go to Page, it's tab 21, page 266 in the supplementary bundle. Transopco itself describes its app as providing a ride-hailing service. Indeed, here we see them advertising themselves as the first ride-hailing service in London to bring black. Yes. Now, the concept of hailing a ride is very often associated with the concept of applying for hire. You hail a taxi. Or indeed a bus at a request stop by raising your arm to signal to the taxi to come over to pick you up. The hail itself, of course, doesn't create any contract. It's just a way of making contact with the vehicle and, in fact, requesting that the vehicle come to you. And the app is just the same. Prior to the advent of the ride-hailing app, you couldn't hail a private hire vehicle unless it was applying for hire illegally. You'd have to ring the licensed operator. And then a private hire vehicle that you'd ask for through the operator, book through the operator, would come to your chosen location to pick you up. Prior to that, the private hire vehicle in our submission had not been applying for hire because it had just been driving around or sitting somewhere hoping that its operator might ring it up with a job. With the advent of the ride-hailing app, you hail a private hire vehicle by opening the app on your phone, and it will know your location because of the phone's GPS settings, so it knows exactly where you are. You enter your destination on the app, and the app will tell you how many minutes away a private hire vehicle is from you, say 1 minute. And you then have only to enter order ride now, and if accepted, the private hire vehicle comes over to you. So in a very real sense, you've hailed a private hire vehicle that is waiting, that is soliciting, whether driving around or stationary, in your vicinity in order to secure passengers such as yourself, without any previous arrangement with you. As you know, my lords, we say that private hire vehicle has been plying for hire since the driver of the vehicle, with the vehicle, opened the Free Now app on his smartphone. And this is a truth that was identified by the current Prime Minister when he was Mayor of London in the article that was published in the Daily Telegraph in October of 2015, which we set out in paragraph 29 of our skeleton argument. That's at page 37 of the core bundle. And in our submission, Mr. Johnson in that article got it absolutely right. That's exactly how the app works in practice. What the court is being asked to do here is to apply the language of the 1869 Act to the vastly different circumstances of today.
Yes, well,
And
that is indeed what we're being asked.
and as Lord Leggatt said in Uber and Aslam in the Supreme Court, the modern approach to statutory interpretations have to regard the purpose of a particular provision and to interpret the language as far as possible in a way that best gives effect to that purpose. And as Lord Stain said in the Quinterville case, and this is these cases were cited below and referred to by the court below in paragraph 27 of the judgment, and they're not before the court today because there's no dispute between the parties as to the relevance and as to these what these cases say. But in Quinterville, Lord Stain said, in order to give effect to a plain parliamentary purpose, a statute may sometimes be held to cover a scientific development not known when the statute was passed. So our case is that applying for hire in the 1869 Act is properly understood as referring to the activity of private hire vehicle drivers working off the Free Now app, notwithstanding the fact that such activity was, of course, entirely out with the ken of Parliament in 1869. And that this understanding is consistent with the principle of exhibition, properly interpreted in its broad sense, as we've discussed, and is necessary in order to give effect to the plain parliamentary purpose underlying Section 7 of the 1869 Act. And my Lord, the only case, there's only one case where the courts have considered whether a private hire vehicle driver whose driver's working off a ride-hailing app is applying for hire is the Reading case. Can I take my lords to that, please? It's in the authorities bundle at tab 30, which is...
Shall we break off now that you've reached Reading?
Yes, that would be a convenient moment, my lord, yes.
And are we going to look first at the Chief Magistrate and then at the Divisional Court, or the other?
I wasn't. I'm in my lord's hands, of course. I wasn't going to take without any.
Well, they refer in this court, in this court's judgment, Lord Justice Fraser refers to some findings of fact made by the Chief Magistrate, but I don't think they're in dispute.
I don't think they are. No,
Certainly
no.
not.
So I wasn't. But I'm again. Of course, I'm in the court's hands.
We'll come to the Divisional Court in Reading and Alley at 2 o'clock.
If you please, my lord. Thank you.
Otherwise,